would everyone please ensure that they have switched off any electronic devices or turn them to silent mode. We now begin line-by-line consideration of the bill. The selection grouping for today's sitting is available in the room or on the parliamentary website. This shows how the clauses, schedules and selected amendments have been grouped together for debate. The purpose of the grouping is to limit, insofar as possible, the repetition of the same points in debate. The amendments appear in the amendment paper in the order in which they relate to the bill. A member who has put their name to the lead amendment in the group is called first, or in the case of a stand-part debate, the Minister will be called to speak first. Other members are then free to indicate they wish to speak in the current debate by bobbing. At the end of the debate on a group of amendments and new clauses schedules, I shall call the member who moved the lead amendment or new clause again. Before they sit down, they will need to indicate if they wish to withdraw the amendment or the new clause or seek a decision. If any member wishes to press any other amendment in a group to a vote, and this includes group clauses and schedules, then they need to let me know. I hope that brief explanation is helpful. I remind members about the rules on declaration of interests as set out in the Code of Conduct. We start this morning with Amendment 10 to Clause 1, with which it will be convenient to consider Clause 1 and Clause 2 stand part. I call Matt Figures to move Amendment 10.
Thank you, Mr Morrison. It is a pleasure to serve under your chairmanship. The subject of this bill is incredibly important to this country and its future. I hope that during the next 2 weeks, this Bill Committee will give us a constructive opportunity for consideration and strengthening. I briefly outline our first amendment as presented to the committee. Clause 1 creates the Border Security Commander as a statutory office holder and requires the Secretary of State must designate a civil servant as the Border Security Commander. As Tony Smith, former Director General of the UK Border Force, said in evidence to this committee, I'm not sure what he will actually be able to command. Well, I'm not sure he'll actually be able to command anything. He's probably going to be more of a coordinator. That's why we've tabled Amendment 10, to leave out designate a civil servant as and insert appointee in Clause 1. The effect of this amendment will be to remove the requirement that the Border Security Commander has to be a civil servant. We think the status of the Border Security Commander is crucial if the role is to be in any way meaningful, as well as the Commander's functions and priorities, which I'll come on to in later amendments. As the Minister is well aware, there are organisations that do not require civil servants to run them. Implementing this structure ensures their independence and reduces the internal, day-to-day political struggles that can easily be imposed upon them. Allowing recruitment from outside the civil service may also provide a wider talent pool and prevent the role from being relegated to that of another senior civil servant within the department. During evidence sessions, we heard about the wide array of roles already in place within the Home Office. This highlights the clear distinction between existing positions and the importance of securing our borders. I'd be very grateful for the Minister's answers to the following questions. Why has the Government decided that the Border Security Commander must be a civil servant? What is the operational benefit of this decision, and why would the Border Security Commander not benefit from greater independence? What level of seniority will the Border Security Commander be? Tony Smith assumed in evidence to this committee that the post would likely be Director General. Is he correct? And why have the Government made this decision? Fundamentally, if Mr Smith is correct and the Border Security Commander cannot actually command anything, and we will discuss this in detail in later amendments, then what is the point of this position? Clause 2 sets out the Border Security Commander must hold and vacate the office in accordance with the terms and conditions of designation. The bill says that the terms and conditions of designation as Commander are to be determined by the Secretary of State, and that is all the information we get. I'd be grateful if the Minister could explain to the committee what the terms and conditions of a designation as Commander would be. For example, if we compare the situation of the Border Security Commander, allegedly responsible for the security of our border, with the Commissioner of the Met Police. The Police Reform and Social Responsibility Act 2011 sets out that the Commissioner has to be suitably qualified. No such requirement appears to exist in legislation for the Border Security Commander. Can the Minister explain why not? What would count as suitable qualifications for someone to take up the post of Commander? If the Secretary of State determines that a person's designation as Commander should be terminated, the Secretary of State must give the Commander a written explanation of the reasons, give the Commander an opportunity to make written representations, and consider these before making a final decision. This seems sensible and in line with other positions, such as the Commander of the Met, which ought to be vaguely comparable in terms of responsibility. Thank you.
Minister.
Thank you very much, Dr Morrison. It's a pleasure to serve with you chairing our proceedings this morning. Look forward to many, many hours of that, as I'm sure you do. I would like to just set out for the committee what clauses 1 and 2 of the bill do, and hope to persuade the committee that Amendment 10 is not required. Clauses 1 and 2 of the bill set out the role of the Border Security Commander and details the terms and conditions by which they hold the office. The Opposition's Amendment 10, the purpose of which is to remove the requirement that the Border Security Commander be a civil servant. The Honourable Member for Stockton West, I'll learn all of these by the time we get to the end. The Honourable Member for Stockton West seemed to be saying that he thought there was operational benefit in complete independence. I suppose that is one way of trying to look at this, but actually there's a benefit in coordination and being attached to a central strategic point as well. And the government believes that the central strategic point and attachment rather than total independence for the sake of it is more likely to be effective. Now, I think as part of that, Amendment 10 implies that the Border Security Commander shouldn't be a civil servant. The role of the Commander is a civil service role, and the Border Security Command is a directorate within the Home Office. As part of the recruitment exercise, existing civil servants could be appointed in future, or the role could be advertised externally. So there's no limit one way or the other from the arrangements in Clause 1 about where the Border Security Commander might actually come from. Could be internal, could be external. So I hope that's some reassurance. But the mechanism of appointment is a civil service recruitment campaign to ensure that the best candidate is selected on merit. It's logical that, given the role sits within the Home Office and leads the functions of a directorate within the department, that this role would be a civil service role. The idea is to cohere, not to fragment the work that's done. I see it very much, Dr Morrison, like ensuring that all of the cogs across government actually connect with each other, so when you turn the wheel, you get something out at the end rather than a load of cogs which don't adhere, sort of not leading to a kind of outcome that's more effective than the one you'd get without having that arrangement. Clause 1 sets out that the Secretary of State must designate a civil servant as the Commander and will make the necessary arrangements to ensure the resources are available to support the Commander in exercising their functions. Through this new legislation, the Border Security Commander will be placed on a statutory footing which will future-proof and solidify the role and ensure a clear direction and leadership for the UK's border security system. Placing the Border Security Commander under this new legal framework is a clear signal of our determination to tackle organised immigration crime by going after those criminals that put lives at risk and undermine our border security. Dr Morrison, Clause 2 details the terms and conditions of the Commander and how they will hold, maintain and vacate the office. This clarity is necessary to ensure continuity in the role and underlines the Government's commitment to making the Border Security Commander an enduring office. I move that... well. Sorry.
It's terrible. Katie.
Thank you,
Sorry.
Dr. Morrison. No, that's all right. I suppose what we on this side struggle to understand is why the law must set out that this person, the Border Security Commander, must be a civil servant. The Minister says Amendment 10 implies that Commander shouldn't be a civil servant, but all it seeks to do is remove the requirement. If the Home Secretary, and indeed presumably the Permanent Secretary of the Home Office, believe the role is best filled by a civil servant, perhaps for the coordination reasons the Minister set out, so be it. They can still be appointed as a civil servant, but this legislation will mandate that they have to be, and we struggle to understand why that requirement is necessary.
Thank you, Dr. Morrison. I think I made clear in my remarks in response to the Honourable Gentleman, the member for Stockton West, that the recruitment could be done externally. So if somebody were to be appointed who was not a civil servant when they applied, they would then come into the Home Office on civil service terms, bringing with them whatever experience that they had, that the recruitment process had thought that would be suitable for the role. So I'm not sure there's very much between us unless the Honourable lady, the member for Kent, Weald of Kent, is implying that by the act of becoming a civil servant somehow the command gets to be less effective. I don't believe that is the case, especially as the idea is to ensure that the Border Security Commander can convene the entire system across government departments. I think that having a base within the Home Office, albeit designated as a civil servant, actually makes that more effective rather than less effective. But to be clear, any holder of the office in future, if this legislation is on the statute book, wouldn't have to come from the civil service. I hope that that reassures her on her point.
I thank the Minister for that response. That is reassuring. I suppose, though, it doesn't quite address... These issues are very difficult, and I presume the Minister accepts that it's possible that it might be better, either in due course or in relatively short order, for this person to be operationally independent. And if that is the judgment of the Home Secretary as time goes on, the government will have to come back to Parliament to change the law. Wouldn't it be better just to give yourselves the flexibility?
Thank you, Dr. Morrison. The Honourable Lady implies that somehow total independence from the machinery of government would assist in the job that we wish the Border Security Commander to do. I don't agree with her in that analysis. The Border Security Commander, the job is to convene and cohere, to strategically focus across government departments with a focus on checking that our border security is as effective as it can be. I don't think that total independence is going to add to effectiveness in that context. In fact, operating out of the Home Office at a Director General level, but appointed by the Prime Minister with a special place in primary legislation, is a more effective way, I think, and we believe, of ensuring that the Commander's basic role has the biggest percentage likelihood of being effective.
Mike Tapp.
Thank you, Dr. Morrison. I think the Minister's been really clear that, of course, we can recruit from outside the civil service, and that being within the civil service equips that person with the powers, the tools, and, of course, the access to be effective in that role. I'm slightly concerned that the Honourable Member has raised this amendment off the back of oral evidence from Tony Smith, who, with full respect, did retire 13 years ago from his role. Whereas on the same day, we had the Director General from the National Crime Agency, who I will read out what he said. For me, I have worked really closely with Martin Hewitt already, and it works well. It allows me to focus on the operational leadership of tackling the organised crime threat, and Martin to have the convening power and to work across Whitehall on a range of issues. It provides clarity, and we have more than enough to get on with within the NCA in tackling organised crime. On the same day, we heard oral evidence from Jim Pearce, MPCC lead for organised immigration crime. And he said, I sit on Martin's board, so strategically I am heavily involved, and members of my team sit within the operational delivery groups. Speaking from a personal point of view, his strategic plans over the next few years make absolute sense in terms of what he is seeking to achieve for the Border Security Command. Thank you, Chair.
I thank my honourable friend, the member for Dover, isn't it?
Yes.
Dover and Deal. I was just checking that I got my honourable friend's entire constituency name, because they've all changed, Dr. Morrison, and it can be a bit disorientating when you're used to the old names. But my honourable friend, the member for Dover and Deal, is exactly right in that he demonstrates. From the evidence we heard, particularly from the NCA, the CPS and the police chiefs last Tuesday? Last Thursday, that there is and there was a gap, that was a strategic gap. Everybody doing fantastic work in the NCA, in the police, in HMRC, in the security services, but nobody taking a very focused look about how border security can be the most effectively delivered in this instance. And there seemed to me, and this has been the case from meetings I've had since Martin Hewitt took up his post, almost a relief that somebody's doing that. Is convening a board where they can have analytics about where the threats are, how they're developing, how we can best deal with them, and do that legwork in coming up with a strategy that is focused particularly on border security. And that's the whole point of creating the command.
Chris Murray.
Thank you, Dr. Martin. It's a pleasure to serve under your chairmanship. I'd just like to make a couple of points, if I can, about the proposed amendment. I think, as the Minister set out, it doesn't mean, of course, that someone who isn't a civil servant can't apply for the role. But actually, that's an increasingly... I think we've got to be careful not of having an old-fashioned view of how the civil service operates. That's increasingly common as outside specialisms are required by government, and it happens even not at particularly senior roles nowadays. But what it does mean, even if an external candidate applies, is that they get the support of the civil service, and they're, for example, if you compare that to the role of, in the Home Office, one of the independent inspectors of Borders and Immigration, or the Commissioner on Modern Slavery, they're sort of very separate to the apparatus of the Home Office, and often report, especially at the Home Affairs Committee, they don't get the support and the structural backing that they need. This would obviate that. And also they would be subject to the Civil Service Code, which is very important when we're talking about the sort of high levels of public expectation this role would have. The one difference this would have with other Directors General or other senior figures in the Home Office largely is that it's set out in primary legislation. So actually we are creating a distinction in this role just by the passage of this Act. The Shadow Minister suggested that we should discuss the suitable qualifications for this role, but actually they're very operational, so I think we should be wary of setting out in either legislation or in this debate the exact specifications of every task. And then just finally on this role, I think we've got to be careful of the pendulum not swinging with one government in one direction and then with a change straight back in the other and just repeating the mistakes of the past. So if we go back to 2010, when the Conservative government came into office, the coalition government, sorry, the UK Border Agency, as it had been under the Labour administration, was restructured by the Home Secretary, Theresa May, now Baroness May. And her comment at the time was that UKBA had been structured in such a way as to be so independent that it would keep its work at arm's length from ministers. Quote, that was wrong. It created a closed, secretive and defensive cultures. The new entity of UK Border Force will sit within the Home Office and report to ministers. So I think it's important that, although we are trying to correct what has clearly gone wrong over the previous 14 years of Conservative government on Border Force, We don't overcorrect and go back to the situation we were in before, which Baroness May pointed out didn't work then.
My honourable friend for Edinburgh East and Musselburgh makes some very good points about particularly overcorrection between governments, the fact that independence for particular posts is an obvious thing that one should go for in inspection areas, for example, but not necessarily operational areas, and that we have to try to cohere a system to ensure that all of the different good work that's being done across government in different departments can actually be focused strategically on the one aim, and that, Dr. Morrison, is what these clauses seek to do. And I can't see anyone else standing, so I move. Yep.
Tom Hayes.
Yep.
Thank you, Dr. Morrison. It's a pleasure to speak today and to be under your chairpersonship. I wanted to, in this amendment and in this clause, take on a principal point which I've heard levelled by the Honourable Member for Stockton West here and also at the second reading debate, but also colleagues of his on his benches, which is that the Border Security Commander cannot command. And I think it's really important that we do address that point here. So from 2018 up to 2023, we saw the number of small boat arrivals increase from 299 to 29,500. That's a 100-fold increase. And as I understand it, some of the explanation given by the party opposite is that the matter became very complicated. That we were seeing an increase in organised crime activity. And to their credit, this was reinforced by the Director General for the National Crime Agency, Rob Jones, when he said that the problem that we need to focus on is the organised crime element, which needs concurrent effort in a number of areas. And he highlighted some of the challenges being the need to undermine the business model that supports organised immigration crime, the need to tackle illicit finance, the need to tackle the materials used in smuggling attempts, the need to tackle the supply chain that supports them, the need to tackle the high-value targets based overseas who are involved in supplying materials and moving migrants. And these were just some of the things that he highlighted. So if we acknowledge that there is a more complicated situation which this present government faces, then I think we should agree that it will involve, as Rob Jones said, a suite of tools. He said that there is not one thing that you can do to tackle these problems. Sarah Dineley, who's the Deputy Chief Crown Prosecutor, concurred with her colleague when she said that she does not believe there's one single measure that would impact so significantly that it would reduce migrant crossings to zero. Jim Pearce, who's the MPCC lead for organised immigration crime, highlights the same point. Now, if the situation is so complex, if there is a need for a suite of tools which are being strengthened by this bill, then surely there is a need for greater coordination. And if there is a need for greater coordination, surely that will help to fix some of the strategic challenges that our immigration system and our asylum system have faced in recent years. And so to coordinate is to command. And I think it is crucial that we actually accept that point, because if we don't, then we're not going to actually be able to tackle the backlog that we face. We're not going to be able to implement the measures in this bill, and we're not actually going to be able to secure our borders. And I just want to close by saying that while we've seen amendments around aspects of the Border Security Commander role, from debate in second reading, I'm not entirely certain whether the Conservative Party support the role of Border Security Commander at all. We've heard colleagues talking about what is Martin Hewitt doing with his time in that debate. So I would really welcome the Honourable Member for Stockton West explaining whether the Conservative Party do in fact support the role of Border Security Commander and Border Security Command, because we clearly heard from the spokespeople at oral testimony, who are very operationally focused, experienced and expert in their field, that the necessity of such a command is important. Indeed, Enver Solomon, who was the Chief Executive of Refugee Council, summed it up well when he said the Border Security Command is an understandable response.
Yeah, so I think, well, valid point. I think we'll come on to in a minute where the aims, the objectives, and how the fact that we'd like to border, if we're going to have a Border Security Commander, this person should have a very meaningful role that can make a real difference. And I think we'll see that in the next amendment. But I would like to press on Clause 2 of the bill that says about the terms and conditions of a designation as Commander to be determined by the Secretary of State. I'd be grateful if the Minister could explain to the committee what those terms and conditions of designation might be. As I mentioned, the police reform and Social Responsibility Act sets out how the Met Commissioner must be suitably qualified. What sort of qualifications could we expect a senior commander? What will those terms and conditions be?
Constance?
Well, I don't really want to read out the job description, which was put out there ahead of Martin Hewitt being appointed last year. It's there for all to see. It's a public document. The role is very much about being able, both operationally, to cohere the system, to make certain by the operation of the Border Security Commanders Board, upon which sit many of the other parts of government that need to have regard to the strategy, how to take forward and deal with threats to our border security. It's not really rocket science, and I don't think that there would be much to be gained from putting the details of all of that into primary legislation. It's important that as the threats to our border security evolve, which they certainly will do over time, that we don't find ourselves with a very rigid set of requirements in primary legislation, which is hard to change. And so the idea is to have convening powers, to give flexibility to the commander to ensure that he can bring together all of the forces across government that are charged with security in this area, and ensure that the focus on organised immigration crime and border security is always at the forefront of the work that they do.
Katie Lamb.
Thank you, Dr. Morrison. I'm a little confused by some of the contributions from the government members. They seem to be advocating for the commander to be a civil servant, and that is fine, but that's not actually what we're discussing. The question here is whether there could be any benefit in having some flexibility for the Home Secretary to do something different, and we don't feel that that point has been answered.
I wonder if the Honourable Lady would go into more detail about what she means with respect to that. I've given her, Dr. Morrison, an assurance that the Border Security Commander could come from outside of the civil service and be appointed from outside of the civil service, but would then take up a civil service role of convening within government with the support of government, which means we don't have to set up an entirely new independent structure and fund it separately, which in my view is more likely to disintegrate rather than integrate the strategic approach to this multifaceted problem. And I'm beginning to wonder what she's got against civil servants.
Nothing whatsoever, Dr. Morrison. The question is merely, and there are lots of parts of the Home Office where this principle is accepted, that sometimes, particularly for difficult things and particularly for things that the department has struggled to achieve, that independence can be valuable. But I mean, it sounds like the Minister is saying that she doesn't feel that that's the case, and of course we must accept that, but we don't have to agree with it.
True, Dr. Morrison. Independence has its part, and is a very valuable part, particularly of holding structures and government structures to account. So, for example, the independent inspectors of our detention estate, for example, or prison estates, who are allowed to go in and publish without fear or favour what they find there. That is obviously a very important role where independence matters. But in this context, the Border Security Commander is cohering the effect and the work across government of trying to keep our borders properly protected. That's operational. It ties into diplomatic and political as well, although obviously ministers have an important part to play in that too. And it seems to me that the Honourable Lady has nothing to worry about when it comes to the Border Security Commander sitting in a civil service context, given the fact that nothing in this bill means that anyone who wasn't a civil servant, when they applied to the post of Border Security Commander, would be considered. Being in the civil service to begin with is not a requirement.
We don't wish to move this to an amendment.
Cool. Is Is everybody else content for the amendments to be withdrawn?
Aye.
Amendment by leave withdrawn. Clauses 1 and 2 have just been debated. With the leave of the committee, I will put a single question on those clauses. The question is that clauses 1 and 2 stand part of the bill. As many as are of that opinion say aye.
Aye.
To the contrary, no. I think the ayes have it. The ayes have it. We now come to Amendment 1 to Clause 3, with which it will be convenient to consider Amendments 12, 13 and 11, and new clauses 7 and 21. I call Pete Wishart to move Amendment 1.
And thank you ever so much, Dr Morrison. It's a pleasure to serve under your chairing this morning. It's a good 10 years since I've had the pleasure and privilege of being on a public bill committee, or standing committees as we used to call them back in the day. I'm really hoping it's going to be as much fun as I remember them over the course of the years. 10 years ago I was, of course, Home Affairs spokesperson. I saw a number of bills quite like this, Dr Morrison. I refer to them as the good old-fashioned stop them coming and boot them out bills. And there's been a succession of them in various governments over the course of the years. And I know the Minister knows I hold her in great respect and affection, and I wish her particularly well on this bill, but I see... Of course I will.
Thank you. I'd like to thank you for giving way. And of course I hold him in similar affection. I think we're pretty long in the tooth. We're the two people that are the most long in the tooth, Dr Morrison, in this bill, and I look forward to listening to his arguments.
Well, I'm very grateful to the Minister. I hate to think the number of combined years that we've had in this House, but it certainly would almost span half a century. So I'm grateful to the Minister for that. But to this bill, and the first 12 clauses, of course, are totally dedicated to putting the Border Commander into statute. Clause 3, of course, lists the functions of the Border Commander and outlines and defines some of his responsibilities. It states that a Border Commander must be appointed by the Home Secretary, who will now be obliged to prepare annual reports, and a board appointed to assist the Commander in the exercise of the Commander's functions. But I don't know about you, Dr Morris, but last time I looked, I seem to think there was a Border Commander already there. A Border Commander that was actually doing the job as outlined in this bill pretty effectively, and doing pretty much as the Home Secretary has been directing them, and of course doing that job without the need of being put into statute. And if I went this evening, I remember Martin Hewitt being appointed as the Border Commander and doing all of these things. But here he is, Mr Dr Morrison, 12 clauses of a bill, the better off and secure in the knowledge that he is now in statute. And all of this sort of makes me think of the BBC Scotland series, The Chief, and I know the Scottish members in the committee will know what I'm talking about, the fantastic new spin-off of Scot Squad, which features the mythical and fantastic character Chief Commissioner Mickelson. Now, Chief Commissioner Mickelson's a complex character, a bit self-aggrandising. He's always getting himself on the wrong side of various issues around the culture wars, which he's pretty uncomfortable with and always manages to upset or offend somebody. Now, I'm pretty sure he's exactly the opposite of Commander Hewitt, and who I believe is a modest, nice, easy to get on with person. I've not had the pleasure of meeting him so far. There's a couple of things I've got in common, which I'd just like to explore a little bit when we're looking at the functions and the job of the Commander. Because it strikes me that Commander Mickelson would love to be in statute, of course, 12 clauses in a bill. He would look at this as some great calling card to all the government functions going to. And they've got the threat, the similar type of threats. With Commander Nicholson, it's the BAMs that make his life a misery, that he needs a whole load of new powers to repair. And of course with Commander Hewitt, it's the illegals. So I think as we go through this bill, let's wish Commander Nicholson and Commander Hewitt and Chief Commissioner Nicholson all the best as they tackle the threats. Yes, of course.
I thank the member for giving way. Would he accept that Commander Mickelson, a fictional character, but the actual role was created by statute by the SNP Scottish Government when they created Police Scotland?
It's a chief. Police Scotland is a chief constable that's in charge of the police.
It's a fictional character.
In Scott Squad, and Commander Nicholson's chief commissioner. I think it's only right that we point out these distinctions, and there is a significant difference between the mythical character, the fictional character, and the reality of Chief Constable, which has been very efficiently and effectively looked after by the current inhabitant of that post. But I know you want me to get on to the particular amendments, Dr Morrison, and thank you for bearing with that patience with this. Because what my Amendment 1 does is to confirm that the Commander must have full regard to the Human Rights Act and the European Convention of Action Against Trafficking. Now, I know the Minister is likely to tell me that none of this is necessary, as human rights compliance is already implicit with government operations. However, without these explicit legal mandates and safeguards, all of this can be overlooked. And if the Minister is asking us to agree to 12 clauses at the outset of an important bill for a job that's already being done, surely we can agree to one of these functions being about observance to the very important international obligations that we have in the Human Rights Act and in the European Convention Against Trafficking. Now, I don't think there's anybody that's opposed to the Border Commander, and I know there's a few jokes about his comparison with Chief Nicholson, but I think all of us agree that this is probably a necessary, useful role that's being established here by the Minister, and I don't think, even though she was trying to chide our Conservative colleagues, there was much disagreement amongst anybody that this would be seen as a useful role that could help bring together quite a lot of the structure and infrastructure that's responsible for operating in our border security. And there is a discussion about a lot of these tasks being administrative, and again, there's absolutely nothing wrong with that. For something as important as this, I think everybody would like to think that where there is administration, it's going to be effective and it's going to be put in place in a way that we could look at. But what we do need, though, is further clarity about the roles, the functions and the responsibility of the Border Commander. And Clause 3 is supposed to be the place where we find all of these things. And the one thing that Clause 3 doesn't do is actually outline fully, perfectly, roundly and coherently what the actual functions of the Border Commander is. If you look very carefully at all the different subsections, it doesn't say much about what he's expected to do. It lists quite a number of the administrative responsibilities have, which is fair and fine, but I think all of us in this committee, when we're here discussing the role of the Border Commander, would actually just like to understand what he's going to be doing. What is his jobs? What is his prime functions? What will be the responsibilities he has? How will these be discharged? And how will he be open to the type of scrutiny that we, of course, will require as members of this House? There seems to be some provision to speak about the functions without actually identifying any of them. And the only place where you could actually find objectives in Clause 3 is in subsection 1, but they're only objectives to which the Commander must have regard. And that's important, it's just have regard to the particular responsibilities that are outlined when it comes to the different subsections. Subsection 7 to 9 particularly interest me because they seem to suggest that people smuggling and human trafficking to the UK are to be regarded as threats, which seems fair enough. That's what most of this bill is about dealing with perceived threat, about disrupting networks and tackling the gangs that operate their vile trade across the Channel. But the only thing is that the people who board these boats, who are subject to the constraints of these gangs, who are at their mercy, are people who are controlled and reliant, and these people are being totally and utterly ignored with any of these subsections in Clause 3. Their realities, their need and right to seek safety, to reunite with family, to escape situations of extreme deprivation are ignored in everything to do with the responsibilities and functions of the Commander. As a matter of principle then, Dr Morrison, it is vital that this bill should be amended so that the Border Security Commander has regard to objectives concerned with respecting human life and dignity. And that must include specific shared obligations to provide asylum for people fleeing persecution and to enable victims of human trafficking to secure safety from their enslavement. There are concerns that if border enforcement strategies do not include these protections for vulnerable individuals, and victims of modern slavery, they can trafficking victims into further cycles of exploitation. In prioritising enforcement over protection, as this bill does almost exclusively, we risk wrongfully criminalising victims of trafficking, failing to identify those in need of urgent intervention, or worst of all, sending them back to their exploiters. If we stand by our commitments under the European Convention on Action Against Trafficking, then this bill should ensure that the Commander respects these obligations too. Now, as has been discussed already, we know that the Commander is a civil servant. I've got no great view about that, and I listened very carefully to the exchanges that were about the civil service role. But there's a couple of concerns that I've got in relation to the amendment that I bring to the table that I would like the Minister to address, if she can, please. Because we know that the Civil Service Code does not give a clear, enforceable duty to respect the UK's obligations under international law. Now, I'm pretty certain the Minister in response to me will tell me that there will be a general obligation to comply with the law, as that's expected and anticipated with everything the government does in terms of its all responsibilities and actions when it comes to international obligations. But I'll refer the Minister to the recent court case in the High Court. That was, of course, the FDA versus Cabinet Office. I think the government actually won that court case, which meant that any of the civil servants who were involved in compiling these regulations and had to abide by the legislative content and context did not have to oblige and comply with international obligations. At best, it is unclear. So I ask the Minister to please clarify, would a civil servant, which will be the border commander, will he or she in the future be always obliged, totally and utterly, to respect fully all our international obligations, particularly those around HRA and around ECAT? Without these specific obligations in the bill, the Border Security Commander will be presumed to always prioritise enforcement over vital legal protection, possibly and potentially leading to human rights violations. While the Commander is required to comply with instruction as set by the Home Secretary, which again I think everybody would accept would be right and appropriate, they are not explicitly required to comply with the UK's human rights obligation. And for me, Dr. Morrison, that is totally wrong, and it completely skews the whole mode of operandi for our Border Security Commander and facets and features in this bill, which I of course will come back to as this bill progresses. We need to see this in the face of the bill. We've got 12 clauses and various subsections dedicated to the role and the functions of the Commander. Give us one, just one, which says that he must be prepared and obliged to always be in line with all of our obligations when it comes to international responsibility, being a good international actor, being a place that is recognised for exemplary human rights requirements, sign up to the HRA and to ECAT and have them on the face of the bill. I beg to
Amendment 1 to clause 3 as on the amendment paper. The question is that the amendment be made.
I've not come across Commander Mickelson before, but I'll endeavour to catch up on Netflix or iPlayer. Clause 3 sets out... We're on it. Clause 3 sets out the functions of the Border Security Commander. The Shadow Home Secretary correctly pointed out at second reading that the new Border Security Commander can't actually command anything. There are no powers at all in the bill, merely functions. They include, in Clause 3, publishing a strategic priority document, and in Clause 4, a duty to prepare an annual account. The Border Security Commander has no clear powers to command, merely an ability to publish documents and reports. According to the legislation, the functions that the Commander must have regard to the objectives of maximising the effectiveness of the activities of partner authorities relating to threats to border security for the purpose of minimising such threats and maximising the coordination of activities for that purpose. This sounds suspiciously like a coordinator rather than a commander. Indeed, that is exactly what the legislation says. The commander does not appear to be empowered by this bill to command anyone. Clause 3, subsection 5, defines these as a public authority with functions in relation to threats to border security, whether exercisable in the UK or elsewhere, but not the Security Service, the Secret Intelligence Service, or GCHQ. I'd be grateful if the Minister could confirm what is meant by partner authorities. Does the Minister have a list of likely organisations that the Border Security Commander should be able to direct cooperation with? How far does the Minister think the Border Security Commander will be able to impact on public authorities abroad? For instance, what role might French law enforcement be expected to have in having regard to the Commander's strategic priority document? We've tabled Amendment 13, which would enable the Home Secretary to direct other agencies to support the Border Security Commander's objectives and strategic priorities, specifically Border Force, Immigration Enforcement, Police and Crime Commissioners, PCCs, and the National Crime Agency. Ideally, we'd like the Border Security Commander to have a meaningful role and the ability to direct other agencies. But as the government seem unwilling to do so, we thought it might be possible for the Home Secretary to give the Border Security Commander a little support. If the Minister does not want to accept this amendment, I'd like to understand why not. I'd like to understand why the government seem only willing to allow the Commander to coordinate rather than command, and if so, why the Home Secretary could not set up to add some additional impetus. Clause 3 requires the Border Security Commander to issue a strategic priority document which sets out principal threats to border security when the document is issued, and the strategic priorities to which partner authorities should have regard in exercising their functions in relation to any of the threats to the border identified by the Commander. We've tabled Amendment 12 to ensure the strategic priority document issued under subsection 2 must support the Home Office's UK border strategy. We're attempting to ensure that the Border Security Commander is aligned with the rest of the work of the Home Office in securing the border, and I'd be interested to understand why the Secretary of State is not willing to accept this amendment. Yeah.
I thank you for giving way, and thank you, Chair. It's a privilege to serve as your chairship. Given the representations made by the Honourable Member for Stockton West and also Weald of Kent, it seems strange, and I would really appreciate the explanation as to, on speaking to the Amendment 12, and the necessity to support the Home Office's UK border strategy. Why is it, given the comments made about the Border Security Commander having a role within the civil service, does the member want to see the inclusion of adherence to the Home Office UK border strategy, which is headed up by the Director General, who himself is a civil servant?
If we're to have such a position, we want it to be effective, we want to have the relevant powers, but we also want it to be aligned to the other priorities of the Home Office and the work that's going on there. I think that's clear, actually. Amendment 11 would remove the requirement for the Border Security Commander to obtain the consent of the Secretary of State before issuing the strategic priority document. We would like to understand the operational benefits that come from the Secretary of State having to sign off on the strategic priority document. Again, this highlights the lack of meaningful role for the Border Security Commander. Although the strategic policy document should set out what, in the Commander's view, are the principal threats to border security and strategic priorities to which partner authorities should have regard, in reality this document is a diktat from the Secretary of State about the Secretary of State's views, with arguably expose the lack of influence and gravitas of the Border Security Commander's role. Allowing the Commander to issue a strategic priority document without seeking prior permission from the Secretary of State would provide a welcome level of independence for the role. The oversight and consultation of the Board would ensure confidence in the Border Security Command's ability to take all necessary steps to stop these crossings. There may be occasions when the Commander believes it's necessary to act swiftly and implement changes without delay. Removing the requirement for ministerial consent would allow them to act decisively, an approach I'm sure could subsequently be supported by the Secretary of State. Yep.
I thank the member for giving way. I wonder what his view is then of how UKBA functioned, and when Theresa May, now barrister SMA, said that when it had that kind of independence, it became secretive, defensive and closed, and she had to completely restructure the UK border, well, not command then, but the kind of structures around UK border defence, because the independence that he's talking about actually made it difficult for ministers to have proper oversight.
When we talk about this role, this border security commander role that we think is going to smash the gang, so all these problems, have a huge role in creating a secure border for this country, I think it's really important that we allow some element of independence, we allow it some gravitas, and I think, you know what we talked about being tied into the strategic priorities of the Home Office, but giving those people, that individual, the empowerment to get out there and make the difference we want them to make. We want to see this succeed. Allowing the commander, I think I'm going back over. Yeah, allowing the commander to issue strategic priority document with them. No, I'm going back over. There may be occasions when the commander believes it necessary to act swiftly and implement changes without delay. Removing that requirement would allow them to act decisively. We must avoid unnecessary bureaucratic wrangling and ensure that in this critical matter, the commander has the freedom they need to deliver results.
Would the Honourable Member give way? Yeah. I thank the Honourable Member for giving way. 2 quick points. The first was that the Honourable Member talked about could the Border Security Commander somehow command or direct the activities of our international partners. I think I would just highlight that it's this government which has actually strengthened and created new international arrangements, which has made it possible for us to start to secure and securitise our borders. So I think it's really important that we don't sort of pretend the history that has happened didn't happen. We should actually realise that we need to have close international ties. But I'm listening closely to his suggestions for the ways in which he thinks this role could be improved. Is the Honourable Member proposing these amendments because he is seeing the current holder of the office, Martin Hewitt, not discharging the office in the ways that he would like? Could he comment perhaps on whether he thinks that Martin Hewitt is doing a good job or a less than good job, and whether he thinks that the Border Security Commander role as it's currently being discharged is satisfactory?
I think that at some point Martin Hewitt will be superseded. We want to make sure that this role, whoever the post holder is in the best possible position to do the best possible job. So I don't think it necessarily speaks to Martin Hewitt's effectiveness or otherwise, but actually about this role and its fundamental, well, its apparent fundamental role in delivering border security for this country.
It's not about Martin Hewitt's professional competence or his ability as a person to do the role, it's about the role itself. So based on how the role has been configured, does he believe that the present office holder is discharging the role well with the responsibilities given? Or is he proposing these amendments because he believes that somehow the role is lacking?
I think there is an opportunity to strengthen this role so that it can provide that real fundamental change that we're apparently looking for in this bill. Right, I wouldn't want to comment on the individual necessarily. We've tabled new clause 21 to set out some clear and measurable objectives for the Border Security Commander to attempt to give this coordinator some clear direction. New clause 21 would set out that in exercising their functions, the Commander must have regard to the objectives of preventing the boarding of vessels with the aim of entering the United Kingdom by persons who require leave to enter the United Kingdom but are seeking to enter the United Kingdom without leave to enter, or with leave to enter that was obtained by means which included deception. In effect, we want it in black and white in the bill that the Commander will be given the objective of reducing illegal entry to the country, and this is what new clause 21 would achieve. Since 2018, when figures were first recorded, more than 150,000 people have arrived in small boats. As of the 29th of January, 1,098 people had crossed the Channel since the start of 2025. In 2024 as a whole, 36,816 were detected making the crossing. I'd like to understand why the government do not think it's worthwhile to give the Border Security Commander the direct objective of reducing or even ending these. We also wish to ensure that those who arrive in this country illegally will not be able to stay. We know that effective returns agreements work as a deterrent. In government, we cut the number of Albanian illegal migrants coming to the UK by small boat crossings by over 90%, thanks to our returns agreement. In 2022, 12,658 Albanian illegal migrants arrived in the UK by small boat, but this fell to just 924 in 2023, following our landmark returns agreement with Albania. And so we've included in new clause 21 the objective for the Border Security Commander to ensure that a decision is taken on a claim by a person who has arrived in the UK legally is done within 6 months of the person's arrival. and for the Border Security Commander to make arrangements with a safe third country for the removal of people who enter the UK illegally. It's up to the government to put in place an effective deterrent to people crossing the channel in small boats. As the government is repealing the Illegal Migration Act...
Thank you for giving way. I find it quite astounding, actually, that there's any claims of success from the opposition, given that, of course, we had 299 cross in 2018, and then an exponential rise of over 130,000 on the Conservatives' watch. And, of course, you're talking about deterrence. Well, Rwanda forewent. We had over 80,000 cross at the time that it was introduced. And it's also important to note that the whole system in the Home Office had completely ground to a halt. And there's another deterrent that's been overlooked by the Conservatives during your tenure, and that's having a process that actually functions. And what we've got now is record high deportations, and as that cuts through to those looking to cross, will start to serve as a deterrent.
Get a bit further down before we got into records and past. But actually, in real terms, there has been a marked increase in the number of people coming here since the government took office. We're up 28% on small boats crossings. I will give way in a second. The crossings are up 28%. The number of people staying in hotels across the country, we were closing hotels. We now got 8,500 more people. It's up nearly 29%, the number of people staying in hotels. And the number of people, he talks about the number of people being deported, the people who are voluntarily going back, and those who, in real terms, the people arriving on small boats, the number being returned who have arrived on small boats has gone down. Well, in the most recent figures, it's gone down again. We are not getting those people back who have arrived in small boats since this government took office. That's just not the case.
I thank the Honourable Member for giving way again. I won't make a habit of this too much. Look, it's really important to realise that the processing of those that come into the Western Jetfoil and then to Manston takes time. And of course, they will be deported if they are not genuine refugees once the system gets there. It's also really important to note, being the Member of Parliament for Dover and Deal, I often look out across the sea and I can tell when it's a good day to cross and when it's not. And it's important to note on those days that are viable to cross has actually reduced. The Conservatives were only relying on the weather to bring down boat crossings.
I think in the last week we found that the only thing this government's relying on is the weather, actually. But I'll carry on. I'm sure we'll come back to all of these things in due course. It's good to be doing it in here instead of in a news channel somewhere. It's up to the government to put in place an effective deterrent to people crossing the channel in small boats. As the government is repealing the Illegal Migration Act and the Safety of Rwanda Act with this bill, we want to make sure that the Border Security Commander is empowered to ensure that all relevant agencies are working towards taking timely decisions on any claims by illegal immigrants and removing those who enter the UK illegally. If the government...
I thank him for giving way. Thank you, Chair. I applaud the comments by the Honourable Gentleman about a timely turnaround in the processing of asylum claims, something that really concerns members on this side with regard to the IMA and the Rwanda Act. I wonder if he could tell me what proportion of asylum claims under the previous government were processed within the 6-month period that is stipulated within this amendment.
I couldn't, but I could tell you that the backlog is even bigger now than it was when the government took office. If the government was serious about tackling illegal crossings and creating an effective deterrent, they would support new Clause 21. We also want to make sure the Border Security Commander is transparent with the public about how best to stop illegal and dangerous channel crossings, which is why new Clause 21 includes a requirement for the Commander to make an assessment of the most effective methods for deterring illegal entry into the UK, the most effective methods for reducing the number of sea crossings made by individuals without leave to enter the UK, and the most effective methods for arranging the removal to the person's own country or a safe third country of a person who enters the UK illegally. Again, if the government was serious about protecting borders, they would support this amendment. Clause 9 specifies that the Border Security Commander must comply with directions given by the Secretary of State about the exercise of the Commander's functions under this chapter. Can the Minister explain what sort of guidance the Secretary of State is likely to want to give the Commander? Can the Minister explain how the Secretary of State wishes to exercise the powers in this clause? The SNP amendment would confirm that the Commander must have full regard to the Human Rights Act and European Convention against trafficking, on action against trafficking. Given that the Commander's role as drafted by the Government includes no real power or responsibility, I'm not sure what this amendment would actually achieve. Thank you.
Sarah Murray.
Thank you very much, Mr Chair. It's a pleasure to serve under your chairmanship. The Liberal Democrats would like to introduce new clause 7, and the reason for this is that we want to strengthen cross-border cooperation and Britain's role in that process. We believe that we also need to reverse some of the rollback by the last government on the provisions to tackle the gangs involved in modern slavery. And this new clause would require the border commander to meet the executive director of Europol every 3 months, which we believe that specific requirement would help to achieve that goal. And I would like to move the clause. Yeah.
Thank you. Before I was elected and before Brexit, I was the Justice and Home Affairs Attaché at the British Embassy in Paris and helped coordinate engagement between the Home Office, the French Government and Europol. I don't know how aware the Honourable Lady is about how Europol functions, but they have a lot of operations and it's a very busy organisation, and it would frequently take us more than 3 months to arrange a meeting. Wouldn't this clause put civil servants at risk of breaching the law just because they can't get a meeting set up fast enough?
So I think that's a really important point, and therefore if this clause was to be accepted, then civil servants would perhaps have to look at ways to schedule the meetings in advance so that they weren't being done on an ad hoc basis. But thank you, that's all I wanted to say, and I just want to move the clause. Thank you.
Thank you, Dr Morrison, and it's a pleasure to serve under your chairmanship. If this role is ultimately going to be successful with the Border Security Commander, I think it does need to give confidence in its efficacy. And I think, first of all, I just want to take that the title of this, Clause 3, is Functions of the Commander. But as in law, often headings do not necessarily need to lead to interpretation, nor does it actually fully do what it sets out to achieve. Because as a member for Perth and Kinrossshire has highlighted, it doesn't actually set out exactly what these functions are. It sets out that it has functions, but the commander must have regard to the objectives. And these objectives are maximising the effectiveness of the activities of the partner authorities, which I would include, I would assume, Border Force, and also at B, maximising the coordination of those activities. But it just seems that, even as Migrant Voice and Amnesty International gave in their evidence session, that this is just little more than administration in the role that the Border Commander is going to carry out. Now, my concern is what is it actually going to do? Because even with the objective of essentially issuing a strategic priority document, in that, it basically, all that has to do is set out the principal threats to border security and the strategic priorities. Now, I generally just have a question about the efficacy of the Border Commander, because first of all, border security goes beyond just migration here. It also goes to our biosecurity, and it was a point that was mentioned in the EFRA Select Committee the other day. Border Force actually highlighted that they have numerous issues, including breaches of personal imports, which means we are having illegal meats coming into this country, which is a real concern for our border security. And my concern with this role is, at the moment, what is the actual Border Commander going to be able to do? What they actually need is help getting actually monitoring the imports, monitoring and having safe disposal of illegal meats. But here it just seems that the Border Commander is only going to be able to pull together perhaps the Border Force groups and actually just get them to talk about it or list out potential threats. Well, we know what the threats are, we just need action. And I think this is something that Border Force themselves are calling for. They need more powers. My concern is that the establishment of this Border Commander, whilst probably interesting in its approach, won't actually solve the problems that are needed right now. So perhaps the Minister could address what is going to be done in that regard through the Border Commander.
Thank you very much, Dr Morrison. I think Chief Mickelson is going to be on all our lists now. I spend the small amount of time, Dr. Morrison, that I have twiddling my thumbs in life, looking for new detective dramas, and it seems that I've overlooked one because I've been too into Scandi noir when I should have been into potentially Scottish noir. So I'll talk to the Right Honourable member after the session to see if he can give me a little bit more detail so that I can follow up for my own enjoyment. This group contains various amendments relating to the Border Security Commander, including amendments 11, 12, 13 from the main opposition party and New Clause 21, tabled by them. New Clause 7, which the Honourable lady, the member for Mid Dunbartonshire, spoke to, and Amendment 1, which the Honourable member for Perth and Kinrossshire opened our proceedings on this group by speaking to. And we were both reflecting in our slightly earlier exchange about how long in the tooth we both are. And so experienced is the Honourable Gentleman that he anticipated what the answer to his amendment 1 would actually be from the Minister. It shows that he's got a very coherent and experienced view of the way that human rights law actually works, because I think if we had to put on the face of every single bill that treaties that we had solemnly entered into and international agreements which we had in many cases helped to formulate and then put into effect in our own law, if each and every one had to be listed in each and every bit of primary legislation, we'd have an even messier statute book, I would say, Dr. Morrison, than we have at the moment. His amendment seeks to ensure that the Commander has full regard to the Human Rights Act and the European Convention on Action Against Trafficking while carrying out all his functions. Both of those pieces of international agreement and law are ones that have been freely entered into by predecessor governments, which we take extremely seriously as a law-abiding government that believes in the rule of law. The Border Security Commander will be a public authority within the meaning of Section 6 of the Human Rights Act and must act compatibly with the Human Rights Act. That is absolutely the case. It's not explicitly written into the face of this particular bill as his amendment requires. I will in a minute. But that does not mean to say that all of the requirements within those two agreements that Amendment 1 mentions will not be adhered to. I'm happy to give way to that.
I'm grateful to the Minister's response. I can just say to honourable members across the committee that the Chief is available on iPlayer, so if they want to find out and enjoy the 8 episodes that will come their way, I'm sure they'll have a funny... not, perhaps not. I'm sure Dr Morrison would have a few words to say about that. But just on our response, and I did anticipate the response from the Minister, but I don't think there's anything wrong in ensuring that our commitments to international obligations, to the whole force of human rights right across the world, the things that we come into agreement, what's wrong with that being on the face of the bill? And we saw with the previous government how easily international obligations and the international rule of law just be set aside and torn up. So this is what we're asking for, is for this to be on the face of the bill, to give us that security, to give us a guarantee, and to ensure that the Border Commander does pay attention to this, because if it's not compelled to by law and by statute, he'll have no obligation to do it whatsoever.
The Honourable Gentleman needs to rest assured that everything that the Commander does has to be compatible with our obligations under the Human Rights Act, and also having full regard to the Human Rights Act in everything that he does, as well as complying with the obligations that we undertook under the Council of Europe Convention Against the Trafficking of Human Beings. Those things are implicit in every public office holder in the UK, in all of the contexts within which they work. Now, I will, but let me just finish the point I was making. The fact that those things are implicit and not explicitly on the face of the bill does not undermine the commitment that any government that is acting within the rule of law and wants to act within the rule of law will acknowledge. One of the first things that our current Prime Minister said once he'd walked through that door in Downing Street was that we would be a government that actually respected the rule of law and the Human Rights Act. I'm happy to give way.
Thank you, Minister, for giving way. The most comparable piece of legislation on this topic in a devolved context in Scotland is the Human Trafficking and Exploitation Act Scotland 2015. But that clause doesn't require, that bill doesn't require a clause that specifies the obligations to respect international law. These things are implicit in legislation, even on this topic, passed by the Scottish Government.
Well, my honourable friend is exactly right, and I just want to raise one sort of issue that may begin to occur if we decide to move away from the convention that under Section 6 of the Human Rights Act, that all office holders implicitly have to follow the rules of that Act, and start to put, in some circumstances, an explicit clause, as his amendment wishes to do, into particular bills. That might make it look like the implicit duty to adhere to these acts and these agreements doesn't apply if it isn't said explicitly. And that would actually lead to a lessening of protections if judges looking at what Parliament was doing in legislating decided that actually not only do you have to, under Section 6 of the Human Rights Act, take account of its provisions, but not really unless you've actually put it on the face of the bill. We'd actually end up in a worse situation. So I suppose I'm just asking the Honourable Member to accept that that structure is the one that we've taken so far. I can understand why he's sceptical after the behaviour of the last government. But I hope that he accepts that, given the pronouncements of our Prime Minister right from the beginning of this government taking office, that we are not planning on undermining the Human Rights Act or its provisions.
I don't like having to correct the Honourable Gentleman, who's usually very diligent in matters and issues such as this, but the Scottish Human Anti-Slavery Act is fully compliant with human rights legislation, and it is included in the bill, as are practically every single Act of Parliament that's passed by the Scottish Parliament.
I'm not massively familiar with the Scottish legislative statute. I'm happy to give way.
Thank you. Just on that point, it does refer to the Council of Europe protections, obviously, and the definitions are taken from it. But what it doesn't do is require a clause that says it has to give due regard. There isn't a clause in the bill that says that. But it's in an implicit way, just as this bill is, not on the face of the bill in a clause like this.
I feel, Mr. Morrison, like I ought to intervene and sort of separate the combatants. But what I wanted to reassure the honourable gentleman of, especially given the pronouncements of some of that came from some people in the predecessor government, that this government is absolutely committed to the provisions of the Human Rights Act and also the Convention Against the Trafficking of Human Beings. And I hope he'll accept that and withdraw his amendment. Turning to Amendment 12, it seeks to ensure that the strategic priority document produced by the Border Security Commander is supportive of the Home Office's UK border strategy. I think that border security is a fundamental part of the strategic approach to the wider border. And the strategic priorities for border security will help to drive the wider UK approach. They're part of the approach. They're not a threat or a counter to it. The strategic priority document will be consulted upon at the board, which this committee will discuss at clause 6, which has representatives from across the border security system to ensure alignment with wider strategic approaches to the border. The whole point of this bill is to cohere and convene and ensure that there is cooperation across complex systems, not to disintegrate systems, and therefore it would be fairly astonishing if the border security strategy was somehow completely at odds with what the Border Security Commander and the wider system were planning. Amendment 13 seeks to give the Border Security Commander the power to direct the specified law enforcement bodies and personnel in the delivery of his objectives and strategic priorities. But this power to direct, what the honourable gentleman, the member for Stockton West, has called empowerment, isn't required. During last week's oral evidence, we heard from representatives of the National Crime Agency and the National Police Chiefs Council that they welcome and value the collaboration to date with the Border Security Commander, and the arrangements as provided for in this bill will reflect and respect the operational requirements of the various board members. So it's a balancing act between convening and collaborating and cooperating, and it's also a way of ensuring that those who have some independence written into what they have to do in other areas don't feel that they're being made subject to, but are collaborating with. And of course, the most effective commanding is exactly that. It's done with cooperation. It's not done with sort of dictatorial powers or attempts to undermine the independence of other organisations. Under clause 5, partner authorities already have a duty to cooperate with the commander insofar as it's reasonably practicable for them to do so. And under clause 3, partner authorities must have regard to the strategic priorities on which at the board will be consulted and which will be endorsed by the Secretary of State as in clause 3.4b. Amendment 11 removes the requirement for the Border Security Commander to obtain the consent of the Secretary of State to issue a strategic priority document. My honourable friend, the member for Edinburgh East and Musselburgh, has already pointed out that an obsession with complete independence can actually fragment and make it harder for a system to achieve outcomes by working together. And he quite rightly also mentioned that where you get operational independence like that and you're trying to make a system work in cooperation, that can sometimes lead to cultures of secrecy and non-cooperation rather than cooperation which focuses on objectives. This bill wishes to foster cooperation which focuses on very defined objectives and strategies. And we believe in this government that this is the best balance, allowing us the Border Security Commander to publish documents behind the back of the Home Secretary for whatever reason he or she may think fit isn't exactly fostering a cooperative working environment or an environment that's likely to be successful. Whereas the way in which this is expressed in the existing clauses of the bill, we believe is more likely to foster that kind of agreement. As already discussed, the strategic priority document provided for in clause 3(2) will set out the principal threats to border security when the document is issued and the strategic priorities to which partner authorities should have regard in exercising their functions in relation to any of the identified threats. The role of the Border Security Commander is to support the government of the day, and therefore it's only right that ministers and the Secretary of State endorse the strategic direction and collective response of this public authority role in relation to border security, whereas the honourable gentleman for Stockton West seemed to want to give the border security commander powers to do things and remove the requirement for ministerial consent for whatever he wanted him to do, which seems to be setting up the border security commander as in a position that might even be more powerful than ministers. That seems an odd thing for somebody who is a member of Parliament and a shadow minister to wish to do. We think that the right way of ensuring that there's accountability for the way that these things are done is actually to have ministerial involvement rather than set up operational structures which are so independent of ministers that they want to do things behind ministers' backs. Turning to new clause 7, this amendment introduces a requirement for the Border Security Commander to meet the Director of Europol or their delegate every 3 months on the face of the bill in primary legislation, which will stay there for many, many years to come and won't be able to be changed. Even say Europol were to evolve into something completely different, what the Honourable Lady has suggested would mean that the Border Security Commander still had to meet what might be a defunct organisation. So I have considerable sympathy with what she's trying to achieve, but I don't think, Dr. Morrison, that we need to specify that in that very, very particular way on the face of the bill in primary legislation what the Commander should do. I can tell the committee that the Commander has been busy meeting all sorts of people across Europe and beyond in terms of operational cooperation, Europol, Frontex, some of our colleagues in European Union countries who have operational requirements to deal with cross-border organised immigration crime, and he will continue to do that as part of the strategy that he develops. I think it would be onerous and possibly less effective in a minute for this to be specified on the face of the bill. I'm just going to give the Honourable Lady the chance to get up if she wants to respond, and then I'll bring in the Honourable Member.
Susan Murray.
Thank you very much, Dr. Morrison. Thank you very much. The Minister makes good points about the practicalities of this, and I think it's good to hear that she recognises what the Liberal Democrats are trying to do is simply to ensure that we have that international influence in cross-border activities.
Well, I can certainly assure her that I recognise the import of what the Honourable Lady is trying to do with the amendment, and often in these contexts amendments are hooks to hang on debate on so that there can be a little bit more information about the intent of the government, and I can assure her that having very close operational and diplomatic liaison across all of the different structures we have to work with to deal with cross-border immigration crime is absolutely at the centre of what the Border Security Commander will want to do. And so I hope that when we come to it, she, and I know it's not yet, Dr. Morrison, that she won't move her new clause to vote. I give way to the Honourable Gentleman.
Yeah, I think it's quite an interesting contrast. You know, on this side of the House, we want to see a border security commander that's independently empowered to make meaningful changes that we need to secure the border, rather than another civil servant muted by political oversight. I think there's a big contrast in perspective in whether a Home Secretary should be signing off on anything this huge role that's going to make this difference to our borders is going to be able to say. And secondly, I'd like to understand why the government do not think it worthwhile that the Border Security Commander has the objective of reducing or even ending small boat crossings.
I think it's quite revealing that the Honourable Gentleman seems to think that somehow the sort of natural order of things is for ministers to be at loggerheads with civil servants and those people who are operationally charged with delivering on objectives. That may say more about them, Dr. Morrison, than it says about the way that we are seeking to get operational effectiveness and objectives obtained in what we're doing. So I want finally also to come on to new clause 21, which focuses on the functions of the Border Security Commander in relation to the work to tackle small boat crossings in the UK. This is a very all-encompassing new clause, if I might say that, and goes very much beyond the functions of the Commander as set out in the first part of the bill that we're discussing at the moment, in that it seems to want him to be all things to all people. The immediate priority is organised immigration crime at the moment, enabled small boat crossings. The Border Security Command will and necessarily must evolve over time to provide the system's leadership across all threats as they emerge. And we know that these crossings didn't really emerge at all until 2018. And they have become embedded and got to be more and more of a threat over time. But had we been discussing something like this in 2017, Dr. Morrison, small boat crossings wouldn't have featured at all. So it's important that our legislation allows the Border Security Commander in the future to change approaches or focus as new threats emerge. Threats do evolve and they change over time. So this approach is there to account for that, stipulating in legislation that the Border Security Commander has particular objectives which might be important now but may be less important in the future. Well, I will when I finish the sentence. Seems to me to have sort of present an overly difficult way of moving forward, which is inflexible. I give way some.
Thank you. I thank the Minister. Thank you, Dr. Morrison. Presumably, though, it would always remain an objective to bring an end to, as much as is practical, illegal migration.
Yes, I was going to go on and talk about some of what Clause 21 suggests, new Clause 21 suggests that we should do. For example, there's a clause in there on asylum processing, which seems to say that the Border Security Commander should somehow also take over the duty to ensure that that those who arrive illegally should be processed within 6 months, something which the party opposite didn't achieve at all during any of its time. And I'm not certain why the Border Security Commander should be empowered to take over the entirety of the asylum system. The next part of the clause then says somehow that the Border Security Commander should also be in charge of immigration enforcement and be doing removals as well as asylum processing, as well as defending the border. The new clause seems to think that the Border Security Commander should not only be independent, but be virtually all-seeing, all singing, all dancing, doing absolutely everything on the immigration and asylum side that the entire system is currently charged with doing. And I think it's overreach, to say the least. And it's also suggesting that the Border Security Commander should be removing people to a safe third place within 6 months for processing. Well, in all of its years in office, the party opposite never managed to achieve any of those things. And so putting it in a new clause for a government that's been in office for 7 months, which was left the most appalling mess with an asylum system that had crashed with massive backlogs, with a structure in the Illegal Migration Act which made it illegal for us actually to process any new arrivals that claimed asylum after March 2023, and then complains that we haven't sent small boat arrivals home fast enough when we were actually debarred from processing them, takes the biscuit. I hope, yes, I'm happy.
Sarah
Thank the Minister for giving way. I think the intention behind these clauses, as has been identified, is really to try to give some more teeth to what the border commander is supposed to do. As I said, because the way it is drafted at the moment, whilst I appreciate the intention is that it may need to be reactive in the future, but it's actually to try and tackle the aims that all of us in this room are trying to aim for, which is to reduce the numbers of illegal migration. And at the moment, with the border commander only being able to do things such as maximise the effectiveness of other partner authorities or maximise coordination and issuing reports, it's not giving us the confidence that he has the power, or at least we'll see the results of what the government is actually trying to achieve.
Thank you, Dr. Morrison. I don't see why having a new clause which puts the Border Security Commander in charge of the entire asylum system and the deportation system and asking him in legislation to reach processing times that the party opposite, when it was in government, never reached, is fairly astonishing. And I think that has fallen into the trap of empowering the Border Security Commander to such an extent that he seems to have to take over most of the rest of the Home Office. Now, Dr. Morrison, that's not really what we intend to do with this bill, and I think that clause 21 is a fairly astonishing increase in not only the power but the reach of the Border Security Commander, which would be massively disruptive to the entire system and would probably lead to an outcome which is similar to the collapse of the asylum system, that we have had to clean up the mess. To give way to my
Thank you, Minister. I appreciate it. I think this clause is actually more of a political point than a constructive addition to this committee. I think these committees, from being new to Parliament, can be really useful, but I think actually that is far from it, and there is nothing in that clause that's constructive. It's unrealistic, and it feels like it's political point scoring.
Well, not for the first time today. I think I agree with my honourable friend. I hope that when the time comes that we will be voting against this clause.
Katie Lamb.
Thank you, Dr. Morrison. I think the Minister perhaps slightly mischaracterises new clause 21. It states that the Border Security Commander should have regard to, not manage, the wider aims of the Home Office and securing the border. Why would the Minister not want the Border Security Commander to have regard to that?
Little C says making arrangements with a safe third country for the removal of a person who enters the United Kingdom without leave or with leave that was obtained by deception. Ensuring, little b, ensuring that a decision is taken on a claim by a person under subsection 1A within 6 months of that person's arrival in the United Kingdom. If that isn't asking the Border Security Commander to take over the workings of the asylum system, then I'm not sure I understand what the new clause is trying to do.
I think it clearly isn't. So all those 2 points that the Minister just mentioned are subsections of the broader sentence. Number 1, must have regard to the objectives of. It's not saying that the Border Security Commander should carry those things out themselves.
But how on earth could asking the Border Security Commander to have regard to those things actually lead him to, or her, to dealing with border security? It's actually, what it's doing is it's taking away the focus in current Home Office arrangements of immigration enforcement, of the asylum system itself. It's saying he has to have regard to, or she has to have regard to, all of the process of areas that they don't have anything to do with in the department in which this person sits. It would upend working relationships. It would make it impossible and incoherent to deliver any kind of... I'm happy to.
I thank the Minister for giving way. This is now my third bill committee, and I've got to say so far I'm really enjoying this one. But in those 2 bill committees, and indeed in this one, I am sensing something interesting, which is my understanding of what the Conservative Party has been is not quite what it is today. So it feels peculiar to me to be hearing Conservative members asking for this role to have so much teeth, and then to be so prescriptive that this ought to be written into primary legislation. My understanding was that actually Conservatives would typically try to minimise the amount of detail that they would write into primary legislation in order to give freedom to those arms of the state so they can do their duty and their responsibilities properly. And I think that's particularly important when, as I was saying earlier, we are living through a time of significant volatility. The complications surrounding our immigration and asylum system are manifold. And so we do need to give this role significant flexibility in order that they can coordinate and in so coordinating command. And I'm just really struck by what seems to be almost an existential challenge at the heart of modern conservative thinking.
I think, Dr. Morrison, you'd probably not be very pleased with me if I started to talk about existential challenges at the heart of conservative thinking, much as I would like to. But I hope that I've given some reasons why I think that New Clause 21 shouldn't stand part of the bill. Yeah.
I'm thankful for fulsome response about some of my concerns about compliance with international obligations. But the ones you didn't reply to, I'm really keen to secure her views on all this, is the FDA versus Cabinet Office High Court case during the Rwanda litigation, which the government obviously won, which seemed to suggest that any civil servant would not be bound by international obligations. And where does that therefore leave the border commander?
Dr. Morrison, we have a Prime Minister who's made it quite clear right at the beginning of his time in office that this government will be bound by the international obligations that it's signed up to, and I hope that that gives the... well, he's a sceptical man, as I would expect, but I've said what I've said about that. Is the Honourable Gentleman suggesting that we should change the law as a result of the High Court...
The judgment in that court case significantly changed our approach to international obligations and the rule of law. All I'm interested in securing is if the Minister's got any concerns, given such a significant and dramatic shift in the way that the successive governments now approach these issues, will this have any bearing on the operation of the Border Command?
As I said earlier, the Border Security Commander and the Border Security Command will work within the confines of international obligations and human rights law.
Mike Tapp.
Thank you, Chair. My apologies for my lack of timely bobbing earlier. Just like to draw attention to my honourable friend, what's at the very top of the bill from the Home Secretary, which states that in her view, the provisions of the Border Security, Asylum and Immigration Bill are compatible with the Convention of the Human Rights. And of course, that adds to what the Minister has said about those in public office having an obligation to abide by the law. And if they weren't to, there would be legal challenge on that, of course. Thank you, Chair.
First, I will withdraw my amendment. Thank you.
Grateful. Is everyone content with the amendment to be withdrawn? Aye. Shadow spokesman wish to push any of these amendments?
Yeah. If we'd have a Borders Commander, we want an effective one who can publish a strategy without being subject to a political veto, has priorities aligned to the UK border strategy, and when Home Secretaries, and whom Home Secretaries can direct agencies to support. We wish to move the amendments to a division. And I'm right in thinking, it's my first time in this seat, I'm right in thinking the new clause comes later in proceedings.
You're right.
Yeah. Very good.
Which one?
Well, Amendment 12, which amendment are you...
11, 12 and 13.
All of them?
Yeah.
I'm going to put as a single question to all of these amendments. So Amendment 12, 13, 11, proposed clause 3, as on the amendment paper. The question is that the amendments be made. As many of our opinions say aye.
No.
To the contrary, no.
No.
Division. Lock the doors.
Sarah Ball.
Aye.
Jade Bottrell.
No.
Dame Andrew Eagle.
No.
Becky Gittins.
No.
Tom Hayes.
No.
Katie Lamb.
Aye.
Martin McCluskey.
No.
Seema Malhotra. Oh, sorry. Margaret Mullane.
No.
Chris Murray.
No.
Susan Murray.
No.
Kenneth Stevenson.
No.
Mike Tapp.
No.
Matt Vickers.
Aye.
Joe White.
No.
Pete Wishart.
No. ayes were 3, the noes were 12. So the noes have it, the noes have it. Unlock. We now come to the question that Clause 3 stands part, with which it would be convenient to debate Clause 9 stand part of the bill. Minister.
Thank you. Clause 3 and Clause 9 taken together outline the functions of the Commander and the directions given to the Commander by the Secretary of State. Clause 3 ensures that the Border Security Commander has the ability to bring partners together to provide an authoritative source of information on priority and emerging threats to border security through the strategic priority setting process, and the Commander, working collaboratively with partners and with consent from the Secretary of State, will have the authority to issue strategic priorities on border security that partners must have regard to. This creates a new mechanism to ensure that there's a whole of government understanding and collective response to border security threats. The provisions within this clause recognise the varied responsibilities of partners and is deliberate to ensure that the duty does not prevent partner authorities from exercising their existing constituted mandates or setting their own wider priorities. The UK intelligence community are exempt from being defined as partner authorities within the legislation to ensure they are able to carry out their functions without constitutional conflict. However, UKIP will continue to work closely with the Border Security Command on border security matters, and arrangements are being developed that will be agreed by the Home Secretary and Foreign Secretary to ensure that this takes place, and arrangements are required by Clause 5 of the Bill. Clause 9 builds on this by ensuring the Secretary of State can hold the Border Security Command to account for the delivery of improved border security outcomes. As an elected official, the Secretary of State is accountable to Cabinet and to Parliament and can assure that the actions of the Commander are being carried out in the interests of the British public. I move Dr. Morris.
The question is that Clause 3 stand part of the bill. As many of that opinion say aye.
Aye.
Of the contrary, no. I think the ayes have it. The ayes have it. We now come to Amendment 2 to Clause 4, with which it will be convenient to debate Amendment 14 and Clause 4 stand part. I call Pete Wishart to move Amendment 2.
Thank you, Dr. Morrison. I won't detain the committee too long with this particular amendment. It covers the same sort of terrain and ground which was part of my Amendment 1, which seek to include the Border Command to take cognizance of international obligations, most notably human rights, and the ECAP, provisions around ECAP. Amendment 2 is just asking that the Border Commander, when making the annual report, makes reference to his compliance and the work that he's done in order to make sure that we are compliant with the Human Rights Act and with ECAP. And that's all I'm basically asking, Dr. Morrison. Like, there's no good reason why this can't be included in part of his annual account into the House of Commons. It would give us an opportunity to understand how part of his work has been ensuring that these relationships with these obligations have been met, and I think it would be an inclusion that would be worthy of his annual report, and I commend this to the House. Thank you.
Amendment 2 proposed Clause 4 is on the amendment page. The question is the amendment be made. Are you happy with that? Do you want to draw it?
You're asking me to?
First time in the hot seat, we're getting that. Clause 4 would give the Border Security Commander a duty to prepare annual reports which must state how the Commander has carried out their functions and in that financial year, and set out the Commander's view on the performance that year of the border security system, with particular reference to the Commander's strategic priorities. This all seems very vague, and a case of the Border Security Commander simply being allowed to mark their own homework. Can the Minister explain what success would look like for the Border Security Commander? What are the measurable key performance indicators that the Home Secretary will consider? This is important because the Secretary of State, as set out in Clause 2, can dismiss the Commander. So what could a poor enough performance for this to happen? And what would be a success? To try to inject some objectivity and accountability into the process of annual reports, we've tabled Amendment 14. We would like the Border Security Commander to report on the number of persons who have, since the later of the passing of this Act or the last annual report, been charged with offences under Sections 13, supplying articles for use in immigration crime. 14, handling articles for use in immigration crime. 18, endangering another during a sea crossing to the United Kingdom. And 43, articles for use in serious crime of this Act. Or convicted of those offences. We want to know how effective these new offences will be in practice for achieving the government's aim of stopping illegal immigration. The government's own impact assessment admits that very few people will go to prison as a result of the measures included in this bill. Proposals to strengthen and improve the function of serious crime prevention orders, it's estimated that between 0 and 3 prison places, with a central estimate of 1 prison place, will be required per year once the steady state is reached. Introducing an interim serious crime prevention order, it's estimated that between 0 and 1.54 prison places, with a central estimate of 0.2 prison places, will be required per year once the steady state is reached. And in serious and organised crime articles, it's estimated that between 4 and 6 prison places, with a central estimate of 5 prison places, would be required per year once the steady state is reached. And on new offences to criminalise the making, adapting, importing, supplying, offering to supply and possession of articles for use in serious crime, it's estimated that between 4 and 6 prison places, with a central estimate of 5 prison places, will be required per year once the steady state is reached. We think it's important to report both on the new offences relating to immigration crime, which the government thinks will not send any meaningful number of people to prison, and also the new offence of endangering lives at sea, for which the impact assessment includes no estimate. Can the Minister confirm how many people the government expect each year to be arrested, convicted and imprisoned under the new offence of endangering lives at sea? Our Amendment 14 will also require the Border Security Commander to report on the number of people identified as entering the UK via sea crossing without leave to remain. How many of these are detained? Yep.
I'm just wondering about the intent in asking that question. Is the Honourable Member concerned about the availability of prison spaces?
We want to see how effective we think these offences are going to be. We've set it out in part, but we haven't set it, well, the government hasn't set it out on the new offence of endangering lives at sea. I think that's a consequence, well, it is a great consequence. Amendment 14 will also require the Border Security Commander to report on the numbers of people identified as entering the United Kingdom via sea crossing without leave to remain. How many of these are detained pending deportation or a decision on deportation, and how many deported to a country of which the person is a national or citizen, or deported to a country or territory to which there is a reason to believe that the person will be admitted. We believe it's important to have transparency about the role of the Border Security Commander in facilitating removals. If the Border Security Commander is charged with minimising threats to the border, removing those who enter this country illegally with no reason to remain is a big part of being able to successfully achieve that objective.
Thank you, Dr. Morrison. I think that it's important to note for this amendment that, of course, measures of success can change. So by legislating for that means that in a decade, for example, we may well be wasting the time of the Border Security Commander and the Border Security Command. My understanding of statistics and collection is that that's for the Home Office and the ONS, and of course, as those who are prosecuted go through the courts, that will be for us all to see. I also believe that there may be a slight misunderstanding here of what a prevention order actually aims to do and what it is. This is the disruptive measure. This can be used before charge to stop these vile smuggling criminals from operating. Even when they go to prison, it means that they've breached that order. So that estimate being low means that there's confidence in these prevention orders to actually succeed. Thank you.
Thank you, Dr. Morrison. Just to follow up on the point that the Shadow Minister has made here, this duty to prepare annual reports really does feel very much like a self-appraisal, because all they have to do is essentially in this annual report state how they've carried out their particular role and set up their view on the performance. So I think we actually need some more factual evidence here. Like in all appraisals in any work context, you always need to have the opposite feedback, and I feel like that is missing. The ability to challenge this information doesn't seem clear other than it coming from the House. I will just in a moment. So I think the detail is actually really needed here. And I do worry that this is a sign either that the government doesn't actually have confidence in what the Border Security Commander can actually do, if they're not prepared to be able to have the details of the work given here. I mean, I think our amendment here is actually very important. I think the member for Dover and Deal worries that it will be burdensome, but I think this is the minimum information that we should be provided to and should be happily supplied to the House in the interests of transparency, which I'm sure the Minister is very keen to proceed on. So I think that needs to be considered, and perhaps the Minister can address this.
Thank you very much, Dr. Morrison. This grouping contains clause 4, which sets out the duty of the Border Security Commander to prepare annual reports, and 2 amendments. Amendment 2 from the Honourable Gentleman, the member for Perth and Kinross, and Amendment 14 from the opposition. Amendment 2 requires the Border Security Commander to clearly outline how they've paid due regard to the Human Rights Act and the European Convention on Action Against Trafficking by including it in the annual report, which is laid before Parliament. As previously discussed when dealing with Amendment 1, the Border Security Commander will be a public authority within the meaning of Section 6 of the Human Rights Act and must act incompatibility with the human rights legislation. So the Commander will be aware of the risks in relation to trafficking and modern slavery through their work and will continue to comply with the obligations as part of government under the European Convention on Action Against Trafficking and Human Beings. Therefore, detailing that this should explicitly be in the report is unnecessary, which doesn't mean that it won't be, by the way, as I think the Honourable Gentleman recognised in withdrawing Amendment 1, but he's made his point very powerfully. Amendment 14 creates a requirement for the Border Security Commander to include within the annual report a range of statistics relating to the new offences created by the bill and wider relevant statistics in relation to irregular entrants who've arrived via a sea crossing and also deportations. Under Amendment 14, he proposes that the annual report must state how the Commander has carried out the functions of their office in the financial year and set out the Commander's views on the performance of the border security system, with particular reference to the strategic priorities which have been set. Now, the report, as envisaged in the clause, will be laid before Parliament and it will be published, which provides public and parliamentary accountability for the work of the Border Security Command across all threats. The strategic priorities may change over time as threats evolve, against which the Commander would need to report. Now, the Honourable Gentleman for Stockton West asked, in his amendment, is basically being quite prescriptive about what should be in the report, including a range of statistics. But it's clear that we have quarterly publication of statistics in the UK on immigration, which are organised both by the Home Office and also under the Codes of Independence for the Statistic Authority. And there are many, many statistics available very regularly about what is going on in this area. The Honourable Gentleman wants these to be published by statute in the annual report that the Commander will put before Parliament, but with all due respect, I think it's important that the Commander would be able to write his report himself without being directed what to put in it on the face of a bill in primary legislation, especially given that these statistics are available very regularly and are very well looked at and reported upon. So I would say that what the Honourable Gentleman is suggesting here is cumbersome and wouldn't really assist in ensuring that we had accountability and parliamentary accountability and public accountability for the performance of the Commander. The Honourable Gentleman also used Some quotes from the assessments on how many crimes and prison places would be created by some of the new crimes that we're going to come on and talk about in subsequent clauses. But I'm not sure what he doesn't understand about a serious crime prevention order or interim serious crime prevention order. The idea of some of these new powers, counter-terror style powers, which Mr Morrison will come on and talk about in due course, is actually that they prevent crossings, that they prevent crimes happening in the first place, because they allow the police and the National Crime Agency to intervene at a much earlier process and stop crime happening. In those circumstances, it may be that that there would be a lesser form of sentence rather than a more serious prison sentence, but lives would have been saved, exploitation would have been prevented. That's the nature of the counter-terror style power. So I hope that the honourable gentleman will accept that the report will allow public and parliamentary accountability for the work of the Border Security Command, and will withdraw his amendment as it creates too inflexible an annual report for the commander to have to give every year, with too much outside interference in primary legislation.
Dr. Burson, withdraw.
Does the shadow
wish to put it to a division, please?
Okay. Amendment 14 proposed to clause 4 as on the amendment paper. The question is, the amendment be made? As many are as of that opinion say aye.
Aye.
On the contrary, no.
No.
No. Division. Lock the doors.
Sarah Ball.
Aye.
Jade Botterill.
No.
Dame Angela Eagle.
No.
Becky Gittins.
No.
Tom Hayes.
No.
Katie Lamb.
Aye.
Martin McCluskey.
No.
Margaret Mullane.
No.
Chris Murray.
No.
Susan Murray.
No.
Kenneth Stevenson.
No.
Mike Tapp.
No.
Matt Vickers.
Aye.
Joe White.
No.
Pete Wishart.
No.
The ayes are 3, the noes were 12, so the noes have it, the noes have it. Unlock. We now come to clause 4 stand part, which has already been debated. The question is that clause 4 stand part of the bill. As many as are of that opinion say aye.
Aye. Aye.
On the contrary, no. I think the ayes have it, the ayes have it. We now come to the question that clause 5 stand part of the bill. Minister.
Thank you, Dr Morrison. Clause 5 places a duty on partner authorities to cooperate with the commander in the carrying out of their functions. The commander is tasked with maximising the effectiveness of our collective response to border security threats, which requires a whole of government response and will be enabled by this clause. It's recognised that partner authorities have wide-ranging functions that extend well beyond tackling border security threats. The duty set out in this clause extends only so far as appropriate and compatible with partner authorities' other functions. This ensures that partners across the system are working in lockstep to enhance border security, whilst continuing to enable the vital work undertaken by partners beyond border security matters. I so move.
Clause 5 provides that the partner authority has duty, so far as is appropriate and reasonably practicable, to cooperate with the commander in carrying out the commander's functions. It would be helpful if the Minister can explain what the government means by so far as is appropriate and reasonably practicable, please. Under what circumstances might it be justified for a partner authority not to cooperate? Does it mean, as per subsection 2, only so far as the corporation is compatible with the exercise of the partner authority's other functions, or are there other circumstances where partner authorities might not have to cooperate? Again, this clause exposes how powerless the Border Security Commander is. The Commander cannot actually command any of these partner authorities to do anything at all. Subsection 3 requires those who are cooperating with the Commander in their exercise of their functions to put in place arrangements governing cooperation between the Commander and that person. Does the Minister have
order. It being 11:25 a.m, the committee is now adjourned until 2 p.m. Order.
Committee Room 9, sound. 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 Committee